In an indemnity contract, there are only two parties stated. The one is the indemnifier, the promisor, only on the conditions, on the basis that if the loss is going to happen for the promisee, he will only get the amount that is being specified as per the contract. It is not providing the timestamp to commence the liability. It goes with the contract altogether. Good morning and welcome to the session 1 in Unit 3 Commercial Law, where we are going to speak about the contract of indemnity. Now this is very important. Why? Because the contract of indemnity is a legal arrangement between two parties in which one party agrees to pay the another party for a loss or a harm that meets certain requirements and conditions unless the circumstances are specified. Now, this is a very interesting and important thing. Why? Because in this case, when you are going to get into a contract, the other party, that is the person who is going to agree in terms of getting into a contract with you, says that I will compensate in case of loss, and I do agree that if there is going to be any harm of goods or any loss factor altogether, I am ready to give you the compensation unless and until the terms and conditions are different. It's a form of a contingent contract. That's why we need to understand this very clearly. It's a contingent contract which is characterized by all essential elements of the valid contract. So it is very important. It's a form of a contingent contract, which means it's a kind of an emergency, a standby, or a bridge kind of a contract that we are talking about, which is characterized by all the essential elements. So it does have all the factors of the valid contract put inside. So that is why the contract of indemnity is as good as the contract factor itself. So this is very important for all of us to study and to understand. Many times what happens is that when you are going to ship certain things which is very fragile, which is highly sensitive, or which involves a little bit of handling with care, the opposite party agrees to the factor that yes, I will refund or I will give you a compensation. Why? Because the value of the goods is very important and they are ready to take the risk of giving the compensation factor also, and the business needs to be handled with care. So those kind of contract agreements is where you see the contract of indemnity coming into picture. Now, in an indemnity contract, there are only two parties stated. The one is the indemnifier, the promisor, who agrees to make up the damage caused by the other group, is called as the indemnifier. He is the person who is going to be called as the indemnifier. The indemnified, which means the person who is assured of compensation for the damage occurred, is referred to as indemnity holder or the indemnified. So two people whom we are going to see in this contract, one who agrees to pay and one who is going to get the compensation. Why these two people are important is that whenever you look into a shipment or any kind of contracts today, the goods have to travel from a point A to point B. And it is quite evident on the factor, on the role, that many times it will happen in such a way that the contract will involve a lot of meticulous planning. The goods might have got damaged while transport. The goods might have got damaged while loading, unloading. Now what happens for the other party? There is a grievance. He might go back and say, sir, I have not received the goods in the promised condition. You told me that the goods would be handled to me in the best way, but now I have a damage factor. I need some sort of compensation. So that's where the indemnifier comes into picture. He says, I will take care of that. See, the transport company itself promises in case if there is any problem that has been happened because of that. So he says that, yes, I will give you back. In the case of the indemnified personality, that person comes back and gets the compensation in case of any damages that has happened. So you can understand here the concept of transport business, the concept of shipping business, all of these will have the contract of indemnity because they are handling goods which needs to be managed with the utmost critical care altogether. If there is a problem, if there is some sort of changes that happen, then automatically you need to look into it. Followed by the mode of compensation contract can be expressed or implied if a person expresses, agrees to save the other from damages. The mode of contract will be stated while the contract is signified by the terms of the case. The mode of the contract will be implied. How are you going to pay the money? Why? Because when you have agreed to pay something, that means you have to understand that the payment has to be made on time and the payment has to be created by certain means, certain ideology altogether. So that's where we say that the person expresses agreedly. For example, implied factor I'm putting in here, where if a person expresses, agrees to save the other from the damages, he has implied, he has explicitly told that yes, I am going to handle the damages, I will pay for all the damages, I will compensate you, then the mode of contract will be stated. That means it is initiated, it's done. While if the contract is signified by the terms of the case, the mode of the contract will be implied or it will be implied altogether, which means to say that moment it is being stated, it is being told as per the agreement that these are the conditions under which the compensation shall be provided to the other party. We are talking about the contract implied. So this is where the contract of indemnity comes into the picture. Now examples of indemnity contract are given below. Now for example, suppose John had sold Paul a house at Peter's direction. John is the person who sold the house to Paul actually on Peter's direction. Afterwards, it's revealed that Alex is the house registered owner. It is not John, but it is Alex who was the owner of the house. Now, Alex got back on John's sum for selling his house. Now, this is something, why? Because he has done it on his behalf. John will now recoup Peter's fees. Now, John will go back and recoup the fees that has been given to the Peter. Now, this is an implicit form of indemnity contract. So, now you are able to see that on the direction of somebody, John had gone ahead and sold the house to Paul. But then you find out that the house did not belong to John. It actually belonged to Alex. So now Alex gets back to John and says that John's sum of selling that house, he has to get back. So what he says is that now John will go and recoup Peter's fee. So he will go and say, you have to give back me, because that's an implicit indemnity contract altogether. Now, moving further, Beta Insurance Company entered into a deal with Alpha to reimburse company's stock of products worth 50 lakh rupees for a premium of 1 lakh for the damages incurred by accidental fire. This is an explicit type. The first one, what we saw, was an implicit type. This is an explicit type. Now, the difference here that we need to understand very clearly is that implicit is by the statement. Explicit is where you have expressed, where you have told it openly. You have agreed upon certain terms and conditions. Now, let's look into the explicit scenario altogether. Now, the explicit factor says very, very clearly that Beta Insurance has tied up with the Alpha Limited to reimburse the company's stocks of products up to 50 lakh rupees. Yes, that has been told for a premium of 1 lakh. Yes, for a premium of 1 lakh rupees, that 50 lakh product is going to be taken care of. for the damages incurred by the accidental fire. So what is going to happen is the stock of the products is worth about 50 lakh rupees. So you will get the reimbursement for that for a premium of 1 lakh rupees. When are you going to get this reimbursement? Only in the case of an accidental fire happening. This is an explicit contract because the terms are being told very clearly. Only when there is a fire breakout or if there's going to happen something because of the fire accident, then you're going to get a compensation worth back of 50 lakh rupees, for which the company is paying a premium of 1 lakh rupees. Now, the next thing, Section 125 of the Indian Contract Act states that rights of the indemnity holder when sued. The promisee in a contract of indemnity acting within the scope of his authority is entitled to recover from the promisor. What is he entitled? Now, let's first understand the scenario very clearly, that according to the section 125 mentioned in the Indian Contract Act, the person, that is the promisee, in contract of the indemnity acting within the scope. Please understand the words within that scope. The scope means within the scope of the contract, whatever has been told in the contract. Is an authority, is entitled, which means he is in the position, he is in a deserving condition altogether to recover from the promisor. So whatever is the loss that has happened, he can recover from the promisor. What and all he can recover? All the damages which may be compelled to pay in any suit in respect to any matter which the promise to indemnify applies. So which means to say that all the damages, whatever might be the damages which he is compelled to pay in any suit in respect of any matter to which the promise of the indemnify applies. That is very, very important here. So which means to say at any given point of time, suppose if there is going to be some words that have been told in the contract that yes, you are eligible to get compensation only to this extent, that means for the promisee, he will only get the amount that is being specified as per the contract. Now, just because damage happened, you cannot go back and claim the entire amount. Whatever has been specified in the contract, to the nature and scope of the contract, then it is possible. Or else it will become very, very difficult for us to retrieve back all the damages. Now, this is why we say all damages which may be compelled to pay in any suit in respect to the matter which the promise applies to the indemnity factor. Next one, all the costs which may be compelled to pay in such suit if bringing or defending it, he did not contravene the orders of the promisor and acted as if it would have been prudent for him, which means true for him, beneficial for him to act in the absence of contract of indemnity, or if the promisor authorized him to bring in or defend the suit. So what we try to say is that as per the contract, what has been agreed between the promisor and the promisee, if he has followed all the rules and regulation, he has gone exactly by the way that has been told, and then the damages occur because of an accidental factor, then the promisor has all the rights to go back and he has to pay the damages for the promisee. So that is why it becomes very, very important here that the promisee should not have gone and changed anything in between or try to modify the contract or try to bring in some contradictory factors inside. As per the offer document, as per the contractual agreement, whatever they have mentioned, they have agreed upon, and whatever that would act in benefit to him as per the law, as per the system, he is eligible to get that particular compensation. So that's why the rights of the indemnity holder is very, very important when you study that document. Followed by all the sums which he may have paid under the terms of compromise of any such suit if the compromise was not any contrary to the orders of the promisor, for which he would have been prudent for the promisee to make in absence of contract. That is very, very important for him to understand. In case, whatever would have been the normal scenario while you are running through this contract, so in that scenario, whatever has been promised, whatever has been agreed upon to pay the damages to handle that initial case altogether will be paid back to the promisee. Now, why this is important is that today, while you are shipping a goods from a particular place and it has to reach a destination, let's say X or Y. Now, you would have said that in between, if the damages happen while landing, unloading or whatever is that, you might have to pay a total compensation of say 5 lakh rupees. Now, this is the agreed amount as per the contract between the promisor and promisee. Now, suddenly I cannot ratify the agreement. Suddenly I cannot go and change that. No, sir, the value of goods is even more higher. So I am demanding a higher compensation from you. That is not possible at all. What they would say here is that at any given point of time, I need my compensation back at this level. So that is why it becomes very, very important for the person to understand how it requires to work, how he has to understand the contract altogether. So that's why it is very, very important for all of us to see that the contract is being taken care of in the way it has to be handled. The next one, after the indemnity holder is paid for the damage incurred, the compensator shall have all the rights, all the methods and services which can help the compensator from the damage altogether. So it is very, very important here that you see on the factor that all the rights that has been taken care of, that is after the indemnity charges has been paid off, the compensator will have all the rights to all the methods and services which can save the compensator from the damage. The next one is that the essence of indemnity contract is the loss to the party, that is indemnification itself is done only if the loss to the other party is incurred or if it is certain that the loss will incur. Now, this is not every time that I have to go and give compensation, only on the conditions, on the basis that if the loss is going to happen, if there is going to be a damage, if there is going to be any scenario arising like that, then we are going to talk about the indemnification. If there is no loss happening, if there is no scenario like that, then the contract of indemnity shall not hold any good. Now, the Indian Contract Act of 1872, which is very, very important, does not provide for the time of commence of liability for the indemnifier under the contract. It tells very clearly the Indian Contract Act of 1872 does not provide time for the commence of liability of the indemnifier under the contract. They will not do it at all. Why? Because it is not providing the timestamp to commence the liability. It goes with the contract altogether. Now, the rights of the indemnifier, which is very, very important, but in this respect, the High Courts of India held the following rules. So, there are certain rules which have been held. One of the important rules that has been held is that the indemnifier shall not be liable until the loss has been suffered by indemnified person. So, until and unless the loss has been pronounced, it has been proved, and with the evidence it has been shown, there is no need for a compensation coming into picture. Followed by, if the indemnified person has not discharged his liability, and he may compel the indemnifier to make his loss. Which means to say that in the leading case of Gajanan Moreshwar versus the Moreshwar Madan 1942, the judge made an observation in this case that if the indemnifier has incurred a liability, right? Inability to being absolute of that factor, that is the liability being an absolute factor there, he is entitled to call upon the indemnifier to save him from the liability and pay it off. So that is where it comes into picture. If the liability that is going to arise because of the loss, then the person who is suffering the loss, who is under the liability, will have the rights to go back and call the indemnifier and say that you are responsible to compensate me back, save me from that liability. Until and unless there is no mandatory requirement that I go and I have to make up for the payment. So that is very, very important, very, very clear in our methodology, stating that this is where you need to understand and analyze the indemnifier. It is not mandatory every day that I will go and make a payment altogether, but it is also important for all of us to understand, to study here very clearly, that only in the case of loss, only in the case of something which is happening which leads to an absolute liability, then we will call in for a case of compensation. Moving further, with this, I come to the end of this particular session. I hope and believe that all the information shared through this session will be of a great benefit and resource to you. In the upcoming session, we are going to talk about the contracts of indemnity at the next level. But until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.